very much, and we apologize to the witnesses for the brief delay. This meeting is now public and televised. One quick little bit of housekeeping just before we start. The chair would entertain a motion for expenses been distributed. Mr. Payne, second, Mr. Garrison. All in favor? Thank you very kindly. Okay, now we have three witnesses here. We have up to 10 minutes per witness for your comments, followed by a brief question and answer. We have you for the first hour, and so we thank you very much for your patience. And the chair, on behalf of all of this committee, thank you very, very much for coming in today. And so we will start off in the order with Mona Lee, followed by Arlene Gaudreau, and then Mr. McCormick. So, Ms. Lee, you have the floor, please. 10 minutes.
Good afternoon, Mr. Chairman and members of the committee. Thank you very much for the opportunity to appear before you to give a voice to victims and their families in support of Bill C-479, an act to amend the Corrections and Conditional Release Act. I would first like to thank Mr. Sweet and his staff for all their hard work in getting this bill to this point and for his support for victims of crime in Canada. I would also like to thank Sue O'Sullivan, the Federal Ombudsman for Victims of Crime, for her submission and fully support her minor modifications to enhance the bill. By way of background, I wish I wasn't, but unfortunately, I have become an expert in many of the issues dealt with in this bill by way of personal experience. My sister was savagely murdered in October of 1997. He pled guilty to second-degree murder as he covered it up to appear to be a robbery and was sentenced to life with no parole for a minimum of 12 years. We were spared the agony of a long, drawn-out trial, but it was not until 6 years later, in 2003, that I was able emotionally to bring myself to even find out where he was located. Once I did that, I became involved in this system and became a quote-unquote registered victim with all its entitlement. Beginning in 2004, a mere 7 years after the conviction, my family and I have endured the hardship that comes with being a victim involved in the parole system in Canada. From June of 2007, when his first application for day parole was denied, to the present time, there have been 6 parole hearings involving 6 victim impact statements and the torture that goes with them. Forget about every 2 years, ladies and gentlemen. Some of these hearings were held 6 months, yes, 6 months apart. If I may, I would like to take this time to read some excerpts from my victim impact statements to show the gut-wrenching nature of these hearings and what families of victims of crime have to endure. The first is from September 2008, only 1 year after his first application for day parole was denied. To the members of the National Parole Board, I want you to imagine the revulsion that I felt when I came home recently and opened yet another letter from the Parole Board, advising me that he had submitted yet another application for day parole. I was told last July that it would be another 2 years in 2009 before he would be able to apply again, when the minimum 12-year sentence was up. But no, I was told that this case was special and an early decision was being requested. Then I go on to say in the statement, there is currently a petition to the federal government, a copy of which I attached, which is asking for parole hearings every 5 years instead of every 2 years. It states in part, and I emphasize, families of homicide do not get parole for their suffering. And repeated parole hearings can be tremendous negative effects, can have tremendous negative effects on the families of the victims. There was another hearing a year later in September 2009 where he applied for full parole and was denied. And and another hearing less than a year later in April of 2010, where he was finally granted full parole, unfortunately. But the story is not over, ladies and gentlemen. Last July, I got a phone call in the middle of the night to tell me that he had been arrested and had his parole suspended. It has now been revoked, and he is back in prison, thankfully. But I am now back in this system, unfortunately. At the time last summer, I was asked to do another victim impact statement, whereupon I said in part, "We all know how disheartening it is to hear the phone ring in the middle of the night. So you can imagine how upset I was to find out by a 3:30 a.m. phone call that he had a warrant out for his arrest yet again. The next day, I found out that he had been arrested and sent to the penitentiary. In spite of strong effort on my part in going down many avenues, I have not been able to find out what he did to cause this to happen. Person after person told me, sorry, he has his right of privacy, and we can't tell you what he did. How fair is this, I ask you? As I pointed out in my previous statement, where are my rights and the rights of my family? No wonder parliamentarians have brought forward Bill C-479, which aims to change, among other things, the right to have a parole hearing every 2 years to up to every 5 years. Each time these hearings come up, we are re-victimized. And now, and we have to relive the events that caused the brutal death of our loved ones. That brings me to the points about the hearings themselves. As they were held in another city, and for the reason that I had never been face-to-face with my sister's killer, I chose to do these statements by audio tape at first and then videotape. I had several occasions where I had difficulty with the execution of these at the hearings. In one case, I was really frustrated by the fact that because I had inadvertently forgot the last part of the written transcript, they cut the tape off before the end of it in mid-sentence. No one even called me to ask me to fax the rest of the statement to them. It was about the killer's right to see it first, and my voice was not heard. There were also occasions where they were not even prepared with the right equipment to show the tape. I was also not even allowed to show a picture of my sister in the video that I made, as I was told that the hearing was about him and not her, if you can believe that. As I mentioned, the true flavor of the hearing was conveyed to me only by the kind person from the victims group who attended on my behalf. The decision register that we receive is so sanitized as to protect the killer with pertinent facts blocked out to protect his privacy rights. That is why I urge you to include the provisions of access to teleconferencing or closed-circuit video feed and to be able to read our victim impact statements at these hearings. We need to be heard and to be able to hear. Therefore, I would ask that one thing that you consider is an amendment to this bill, because the way it's drafted here, it only provides for the fact of teleconferencing if the board decides not to permit a victim to come. I would ask that you consider it to apply to all hearings and not just these ones where the access has been denied, because for somebody like me, this would have been very, very helpful. As I had not seen the offender in person, other than a 15-year-old picture, at the time of his full parole, I asked both the parole board and the Correctional Services of Canada for a picture of him. I was told it was against his privacy rights once again. This man could have shown up at my door, and I would not have known who he was. It was only when I turned to the police that they sent me a copy of a picture of him. This was a matter of my and my family's safety that was denied to me. I would urge you to consider adding this provision with the other information to be given to victims. The more information that we have, the better we can be prepared to participate in this system. This would also include receiving a more conclusive plan for rehabilitation. In conclusion, I thank you for your consideration and would say that this bill is a great beginning for helping victims of violent crime. And I would urge all parties to continue to work together to allow our voices to be heard.
Mrs. Lee, thank you very, very kindly. We do certainly appreciate you coming here today and providing witness. And now we will have up to 10 minutes. Madame Gaudreau, s'il vous plaît.
Oui. Monsieur le Président.
Mr. Chairman, first of all, I'd like to thank the Standing Committee on Public Safety and National Security for giving us this opportunity to take part in the consultation on the bill and to make our contribution to your proceedings. I'd like to thank particularly Member Parliament David Sweet for his commitment to this bill and for the interest that he has shown in advancing the rights of victims of criminal acts. Our Association for Victim Advocacy has been in existence for 20 years, and it works to promote and defend the rights of persons who are the victims of criminal acts. It represents more than 200 organizations working in the field of psychosocial aid and assistance to the victims and their families. We support a good many of the proposals in this bill, and we would like to talk about certain amendments that we think can improve the rights of victims in the present correctional system and the system for parole. I'd like to make my proposals certain groups. First of all, I'd like to talk about the changes made to the presence of the attendance of victims at the hearings. That is the presumptive right to attend the hearings. That is, this is something that has been advocated for a number of years now by the Human Rights Commission. The Federal Ombudsman also reiterated his support. We do support this particular proposal. The only comment that we have to make is that in the present legislation, reference is made to allowing the attendance of victims, whereas in the proposals in this bill, it would be authorizing. In French, allow and authorizing have the same meaning, so it may be something that could be looked at. It's not a question of substance, but rather of form. The understanding of the rights of victims to attend the hearings, this is something that we propose, but we do have certain concerns relating to the implementation, and we probably will have a chance to discuss this during the question period. My third remark relates to efforts that are made to help the victims that are unable to attend. In the case of a refusal, it is said that they will be allowed to observe the proceedings by teleconference or by one-way video feed. We consider this is probably the best solution. But there may be certain circumstances, certain exceptional circumstances, where the security of the establishment or the person may be compromised, and this could be included then, that is a reference to this possibility. We do have certain proposals that are similar to those made by Ms. Lee, namely that when victims are authorized to attend the hearings and when they apply to observe these proceedings by teleconference or by closed circuit one-way video feed, that this request be accepted and that the Act be amended accordingly. We think that this would be a good approach, and we think that this is a wish that has been expressed for a long time by the groups representing victims. The second section relates to changes that are made to the victim impact statement at the parole hearing. In the principles in Clause 101, we see that the parole board must take into account the information that has been provided by the victims. But here, we talk about, there's an explicit reference to the victim impact statement, and we think that this strengthens this statement, and we agree with the proposal being made. The proposals that are also on the table clarify the way in which these victim impact statements will be presented. Right now, it's part of the policy manual. What is considered to be acceptable or not acceptable in the present time. They may be video or tape recordings. There are also statements that are presented by DVD. We agree with this particular proposal, but what we would like to see is a clarification. because in this particular clause it is said that the statement may be presented in the form of a statement and accompanied by a recording. In the present practice, when there is a video or an audio recording, they are not required to produce the statement. Will it be accepted that there may be a written statement accompanied by a video or a tape recording where a relative may be allowed to show family scenes or pictures of a child? I think that there are certain expectations on the part of victims with respect to this. We also make a proposal, like a number of other groups, that victims be authorized to read their statement as part of a video conference. We support this proposal. We would like to make a number of other, some proposals relating to the victim impact statement. We would like to see that the right to read this statement be explicitly included in the Act. This is found in the Criminal Code before the sentencing and in Section 702. And we think that this particular right should be specifically mentioned in the Corrections and Conditional Release Act. The present policy manual of the board, the 9.8, does provide the victims a possibility of presenting a statement at the hearing when there is a waiver, where the hearing does not take place. We would recommend then that this particular policy be included as a part of the legislation. And our last recommendation relates to the policy of the commission of the board, where authorization may be given for a person supporting the victim who may be allowed to read the statement. We consider that this is an excellent procedure. This would facilitate the production of the statement, and we think that this should be a right that would be given to victims. I would like now to talk about the amendments relating to the disclosure of information. There are certain amendments relating to discretionary information for day parole, destination following parole. We support these proposals. There are also proposals relating to the disclosure of the correctional plan. We do have particular concerns relating to this, and I would simply like to make reference to some of them here. It is clear that victims have been asking for a greater amount of information relating to the risks represented by the person, programs being offered within a penitentiary, and what rehabilitation efforts are being taken. The correctional plan might contain information relating to psychological follow-up, medical follow-up, and these come under the Protection of Privacy Act. So I'd simply like to remind you that the Standing Committee on Justice and Human Rights, presided by, did draw attention to the fact that we should continue to apply the test relating to the rights of both parties. And I would like to quote what was said. Some of this information may be detailed and complex. Should we give priority to the victim or and their families, and at the same time compromising in as little as possible the rights of the perpetrator? The committee might perhaps ask for expertise from the parole board so that we can have better appreciation of the circumstances with respect to protection of privacy and safety. The last element, relating to disclosure of discretionary information, relates to the transcription of the hearings of the parole board. This is a matter that was raised and examined in 2000 by the Standing Committee, and it was concluded at the time that it would be preferable, for example, that the victims should have access to these hearings or be able to hear recordings. It was a proposal that had been made by the Ombudsman, and it's one that we were making as well. This often comes up, and this is something that we would like to repeat. This would allow the victims to hear at a later date the hearings or the recording of the hearings of the parole board. And the last point then, I hope that I'm respecting the time limit, relates to the amendments for life sentences. There are certain proposals made by the Ombudsman, and the proposal on the table does restrict the number of automatic re-examinations for perpetrators of violent acts by extending the intervention. I think that Ms. Lee did evoke the difficulties that this poses for the families of victims in particular, particularly in the case of life sentences when this is over a long period of time, and we could perhaps give you more information on our recommendation. We know that it does require a great deal of courage for the victims to attend these hearings, particularly if they occur repeatedly, and this is an extremely heavy burden to bear, and we believe that the proposal that is contained in this bill would allow to take into account the situation of these victims. At the same time, we wonder whether this might be applied in an arbitrary way without us being able to take into account the progress that may have been accomplished by the perpetrators. May I have just 2 minutes for my last point, or will I be able to?
I'm very,
OK,
very
je
sorry.
vais expliquer le
Could
dernier
you,
point.
I'll give you a brief summation very quickly, please.
OK. Pour ce qui est
In the case of the intervals between the various hearings in Appendix or Schedule 1, we are of the view that this could be harmful to the protection of society and the victims. We believe then that it would be preferable for victims to be part of this process. There is a risk that the person might be released without obtaining parole, without them being under surveillance in the community. We do not think that this is good for society.
Thank you. Thank you very, very much. And maintenant, Mr. Mike McCormick, President of the Toronto Police Association, 10 minutes, please.
Thank you. Good afternoon, and thanks for the invitation to come up and speak before this committee on this very important piece of legislation. I'm here on behalf of the 8,000 members of the Toronto Police Association, and also Karen Fraser, who unfortunately wanted to come up with me to Ottawa, but she couldn't make it, as unfortunately she was in Florida in the last several months, had a fall, broke her neck, and she's now confined to a wheelchair. So I appreciate my time is short, so let me give you important context of why we support this bill here in Toronto. One of our own police officers, Constable Michael Sweet, was murdered on March 14, 1980 by Craig Monroe. Michael Sweet was only 30 years of age, and he was survived by his 29-year-old wife, 3 children, aged 1, 4, and 6. Now, all murders are brutal, but the murder of Michael Sweet was particularly brutal and cruel. As he pled for his life, Michael Sweet begged Craig Monroe to think about Michael's children. Monroe did not care, and after abusing Constable Sweet even further, Monroe let Constable Sweet bleed to death. Craig Monroe made a decision that day. The passage of time does not change that decision. Michael's widow, children, parents, and brothers and sisters' pain and anguish continues to this day. They do not get parole from the suffering. Monroe already had an extensive criminal record. He was a very dangerous and violent man. He was charged and convicted of first-degree murder and sentenced to life imprisonment. Life means life. After 25 years, Monroe was eligible for parole, but parole does not change a life sentence. What it does, however, is potentially relieve an offender from the full consequences of their life sentence and their murderous act. We are all committed to the open court principle: justice must not only be done, but it must also appear to be done if our criminal justice system is going to command public respect. The parole system is an integral part of our criminal justice system. It is the back end of the sentencing process. Parole is not a private remedy. Parole is a public remedy, and every aspect of the parole system must be as transparent as the rest of the criminal justice system. Murderers like Craig Monroe and their privacy rights in parole hearings cannot be greater than what they were during their trial and sentence hearing. To the contrary, they should be less, because at trial, Mr. Monroe was presumed innocent. At a parole hearing, there is no such presumption. Quite the opposite. He is a convicted murderer, and the difference is significant. Mr. Monroe has had 3 parole hearings: February 26, 2009, March 16, 2010, March 30, 2011. His 4th parole hearing was scheduled for August 2012, but his privileges were revoked on August 20, 2012 because he breached conditions of his unescorted temporary absences, which we believe he should never have received from the parole board in the first place. In addressing Bill C-479, let me start with the proposed section 144 sub 1, which states, if a transcript of a hearing has been made, a copy of it shall on written request be provided by the board free of charge to the victim, a member of the victim's family, or the offender. Time does not permit, but we have been stunned as Michael Sweet's widow, children, over the changing testimony of Craig Monroe at each of his parole hearings before different panels of the parole board. This has led to inconsistent and contradictory findings of the board, placing Craig Monroe on the fast track to freedom. But for his own predictable breaches, he would have been paroled by now. The anguish and despair that this causes to Craig Monroe's victims is extreme. They see and hear for themselves the lies and the deception of the different stories Monroe tells to different panels of the parole board, but the parole board does not. In our experience, we have never seen a transcript of a parole board hearing. We do know that the hearings are recorded. All of our attempts to obtain a copy of audio recordings of Mr. Monroe's parole board hearings so that we could prepare a transcript at our own expense have been denied to us and the victims on the basis of Monroe's privacy rights. These are public hearings. We were at all 3 parole hearings. Members of the media were at some of the hearings, and there is nothing private about this, nor should there be. So in our respectful view, while we support this proposed amendment, it can be improved by amending Section 144.1 to include a copy of the audio recording of the hearing in the event that a transcript is not available. The annual reviews for those offenders convicted of first-degree murder causes enormous hardships for the victims. No sooner is one parole hearing over that the victims have to prepare new victim impact statements and confront the person responsible for the loved one's murder, as we've heard from the other witness. Not to attend a parole hearing for many family victims is unthinkable. To do so would amount to abandoning their loved ones. Such a possibility is unspeakable unless there is some material change in circumstances. A violent offender, murderer, sentenced to life after their parole, first post-25-year parole hearing, should not be entitled to another hearing for 5 years, and certainly for not less than 3 years. Without going through each section of the bill, we support extending the period of time between each hearing. We have not had a chance to review the 100-plus offenses in Schedule 1 regarding the meaning of offenses involved in violence, but in principle, this legislative change is necessary. With respect to proposed Section 133.11 as it relates to gating applications, that is keeping the offender in jail beyond 2/3 of the statutory release date, we just ask you to consider, for context only, the case of Carla Homolka. She received a 12-year sentence, so she reached her statutory release date after 8 years. She was gated and stayed in jail for a full 12 years to her warrant expiry date. At minimum, extending the review time from 1 year to 2 years is a must. But once you meet the criteria for getting in the first place, after spending so much time in jail to begin with, absent of a material change in circumstances, why should we, the taxpayers of Canada, pay a dime for a further hearing? We fully support Section 145.1, 5.2, and 10.1. With respect to 5.1, you might consider changing the positioning of some of the sentences. In the second complete sentence, it reads, "The board or its designate shall permit a victim or a member of his or her family to attend as observer." That is the important point, and we fully support this. We are concerned, however, that the first sentence of the subsection detracts from this because it deals with the question of the board determining whether to permit a victim to attend as an observer. Either it is mandatory or not. You may want to bring greater clarity to this, given the ingenuity of lawyers to exploit an arguable ambiguity. Nothing personal. The overarching principle expressed earlier is that, to the extent practicable, parole hearings must be open and transparent. When an offender is seeking public remedy from the parole board, that is to be released back into the community, the offender cannot be permitted to hide his records or her records under the pretext of a privacy interest. If Mr. Monroe wanted to stay in jail, he can have his privacy. But the moment they seek parole to be relieved of the consequences of their very public act, a murder of a police officer or a violent offender, and be released back into the community, they have no privacy rights. So we fully support the disclosure to the victims stated in proposed section 142, 5, 6, and 7. We also support proposed section 140.11, but leave you with this observation. If the victim cannot attend a hearing, they may submit a written and/or video impact statement to the board, but you may consider adding that the board shall receive it as evidence, so that the victim has the option of submitting such a statement, but if the victim so chooses, it is mandatory that the board receive it into evidence, underscoring its importance. Finally, section 141, the offender refusing to attend the review hearing, waiving his right to a hearing. Let me leave you with this fact scenario. Michael Sweet was a Toronto police officer murdered in Toronto in the line of duty. Craig Monroe was from Toronto. The trial was in Toronto, but Craig Monroe is incarcerated in British Columbia. The Sweet family must fly from Toronto to Vancouver, then travel to interior BC and attend Mr. Monroe's parole hearings. This is a very expensive, time-consuming, and emotionally draining exercise. On one occasion, at the last moment, after all the flight's accommodations were booked, we were told that Mr. Monroe might seek an adjournment. The point is, you may want to consider a separate provision when there's a significant geographical gap between where the victims reside and where the government chooses to incarcerate the prisoner. Victims don't book flights and accommodation and make arrangements with their employer at the last minute. As you know, the federal government has a program to pick up the expenses for the victims, so Canadian taxpayers have a right to know that their tax dollars are not being wasted. Offenders convicted of serious criminal offenses who lack empathy and feelings cannot cancel parole hearings at the last minute without consequences in this regard. Victims should be consulted when the parole hearings are scheduled and their schedules accommodated to the extent practicable. So if there's a window,
if you would, just close off.
So if there's a window between April and May, the offender is content with that window, then why not consult with the victims to see if there are times within that window that they cannot attend. Thank you for your time.
Thank you very much. Our time has been shortened. We only have time for one round of 5 minutes each.
Thank you, Mr. Chair, and I'd like to thank all three witnesses for appearing today, especially Ms. Lee for the courage to appear before committee and bring your story to us. Very important that it be told, as well as to thank all three of you for bringing forward some suggestions on amendments that we will certainly be looking at. Ms. Lee, I do have a question to you. I wrote your statement down. You said that you are now registered victims and all of it with its entitlement. And you also had said that you have to relive the events each and every time you have to go to a parole hearing. I guess the question that I have to ask, and I know it's difficult, it's such a difficult issue and a difficult time to have to go to parole hearings, but why do you and so many other family members of victims do it? I guess it's a question that we need to ask, because it is it's just terrible all around for you to have to prepare your statements, go to the hearings, and yet everyone does it. Why is that?
As I said, this is not something I ever wanted to be an expert in, but unfortunately I am. And why I do it is for the memory of my sister. Her, as someone said to me, she didn't die. Her life was taken from her, and nobody is there in these parole hearings to represent her. And as I told you, I couldn't even show a picture of her. It's about her. She's the one who's gone, and these parole hearings are all about them and how well they're doing. And as you know, the other panelists have said, they change their statements all the time. And you know, it is our choice. we have the option not to, but if we don't do it as family members, there is nobody there on their behalf.
Thank you. You've also mentioned, if I did write it down correctly, that since 2007, when the person who committed this crime, where he was eligible for day parole and was denied, that since then you've had to go and attend 6 parole hearings. That's a lot in a very short period of time. So I guess the question to you is, had this legislation already passed, had already become law, and the Parole Board of Canada could extend that period of time from 2 years, and you've actually indicated that sometimes it's been less than 2 years.
Oh, sometimes it was 6 months.
If the opportunity had been there to extend it to 5 years instead of the 2 years or 6 months, as you said, how different would your life have been in the last number of years?
So much better. It's really hard to describe what happens when these letters come. And once you become a registered victim, they give you so much information. Sometimes I even had to tell them, stop, I don't want to know every time he gets out, because it just makes you so angry that he's out on unescorted temporary absence, and then he's out, you know, it's too much information. But I just needed to know and this, but my life would have been so much better if I wasn't having to do this every single time, every 6 months, because you have to go through all your files, you have to live all these emotions all over again. I mean, it's not something I can deal with on a daily basis. I mean, it's something that if I started to think about this on a daily basis, I would be, you know, I wouldn't be able to function.
Thank you.
But once you have to do this and get back into it, it just takes its toll.
Thank you, and I think Mr. McCormick actually said it quite well when he said no sooner is one parole hearing over that you're preparing for the next one, the way the current system is. So I really appreciate you making those comments as well. Now, within the bill itself, there's a couple of sections that deal with mandatory disclosure to victims, including the disclosure to victims of the date and time, conditions, and location regarding an offender's conditional release. Do you support those measures?
Yes. Even though I don't live in the same city as the offender, it was still important to me to find out where he was and what he was doing at this time, because I do have other family members who are in that city.
And also with regards to this bill, there's a disclosure, discretionary disclosure to the victims regarding information on the offender's correctional plan. I know another witness did touch on that, and the progress on the plan. Do you think that's important where it's feasible, where it's possible to obtain that information? Do you believe that the victim's family should be entitled? Let's talk about the victims here and not the actual perpetrator. Let's talk about the victims. Do you believe that it's important that you actually have access to that information?
Yes, I do, because can I answer?
Yes.
In the present system, I get every so often sheets of paper that say that he did this or he didn't complete this program. But we need to know more. Like, no one's ever told us what was the plan for him, which obviously didn't work because he's back in. So I think the more we know, the more prepared we are to comment on it in our statements.
Thank you very much. Now, 5 minutes, Madame Duré-Lepage.
Thank you, Chairman. I'd like to start, first of all, by thanking you, Ms. Lee, Mr. McCormack, and Ms. Gaudreau for speaking on this bill. I think it's very important for us to look at victims' rights, and I think that your testimony has been very enlightening today. I'd like to put my questions to Ms. Gaudreau in particular. You didn't have a chance to conclude your presentation. I think that you had reached a point dealing with the amendments relating to parole hearings. Are there particular points that you'd like to add at the outset then? I think that it is important to say that the cause of concern for the victims and organizations that work with victims is that it is important that when a delinquent after serving a sentence that does have a certain gradual reinsertion, I think that it is a better guarantee for public safety and for victims. And there's a significant concern relating to the fact that a victim not be allowed to go on unescorted leave or This is not an amendment that comes from groups defending victims' rights. I did have a close look at what the Ombudsman had to say last week. It's a major change that is being proposed. What the victims would like to see is that when someone goes out, that this person has gone through the appropriate programs, that the person is following the plan, and that there be some type of surveillance. And if there is any breach of conditions, then we'd like to see that all the appropriate guarantees are complied with. There could be a significant impact on the delinquent, or the offender, rather, relating to their motivation. This might have an impact on the system and the costs. I don't know whether they've been assessed, and this is something that we are concerned about. Victims would like to see that these persons are under surveillance, that there be some type of watchdog outside. We consider this to be important. Security of victims, the safety of victims is an important fact that has to be taken into account. Thank you. So as I understand it, I know that you are speaking for the Quebec Victims Advocacy Association, victims of criminal acts, and I'm happy to hear that you talk about a type of progressive type of parole, and the need for some type of surveillance in the case of such parole. Among the victims that you represent, can you tell us whether some of them might be worried by the fact that there will be parole applications for parole every 5 years? This would mean this would have an impact on the correctional system. What do you see the impact of this being? What we are saying is that there has to be some type of discretionary measure, and we've understood from what Mr. Sweet had to say about this bill that these concerns were present in the drafting of the bill. Someone, for example, who has changed and has followed the correctional plan, and someone who has indicated that they would be able to go out on day parole with some type of surveillance. In the case that most offenders will be allowed out at one point or another in the community, therefore we think it is better that there be some type of escort, and this is a principle that has been recognized for a long time. Thank you. I appreciate your answer. I'd like to know whether you consider will you consider parole to be something that is essential in the rehabilitation of offenders and ensuring better public safety? Certainly. I think that this is a view shared by many groups, and it's something that was reiterated in the examination of C10, various groups working with the victims of family violence and so forth. They talked about the need for parole. They support the system, not at any cost. It is something that has to be rigorous. The correctional system will have to do its job properly, protect the victims and take into account their situation. And I think that with a proper parole system, everyone will end up winning. There will be some.
And now we will go to Mr. Payne. Thank you.
Thank you, Chair, and thank you to the witnesses for coming. So my question's through you, Chair, to the witnesses. And I guess I'm going to start with you, Mr. McCormick. You said something about the transcripts were not being available to the victims. And one of the things that popped into my head right away, and you also talked about new members on the board, the parole board, for these different hearings. Would you know, or is there any way to tell whether, in fact, those new members on the particular hearings have actually read the previous statements from the previous times that people actually want, or the victim, or not the victim, the individual who committed the crime was trying to get parole?
Well, again, I think the fundamental flaw in the current system right now is the lack of transparency, especially coming from the victims and going through this process. So there's so little disclosure coming towards the victim, whether or not the new boards, it's our information that so every time we went through this process with Monroe, that we didn't even know what information was being shared, but it was to our information that the boards were not aware of any of the other board's findings. So that what made it worse for us is that the family, Karen and her family, were feeling that, you know, Monroe or somebody else could tailor their statements to, you know, well, what didn't I get right with the first board, and tailor that statement for the next board, because we brought in a completely new panel. So, you know, that's where we get into the lack of transparency. And at least if we had the transcripts, we could ensure, and again, we've asked for transcripts. We've asked for that transparency, not only in his testimony, but also what was happening while he was incarcerated. For instance, one of Monroe's triggers was alcohol and drugs. And when we said, well, has he been involved in any drugs or alcohol while he was been incarcerated? And we were not allowed to get any of that information when he's trying to get access to be allowed in the public again. And here was one of the triggers that he had. And then we found out subsequently that he failed a drug test. Yeah. Like, what? How does that help the victims? How does that help protect society? It befuddles me.
Yes, and you know, the criminal in this case, I'm just absolutely unbelievable that, in fact, the members on the board wouldn't have read the previous statements to find out all the contradictory evidence, and then even allow individuals to go on unescorted paroles. It to me is totally outrageous. Anyway, I know as a police officer you've probably encountered a number of these things, and I wonder if you could sort of tell us some other incidents that this has created as a result of your duties as a police officer and, of course, as the head of the association.
Yeah, and again, you know, as a police officer, again, fundamentally, we support rehabilitation. We understand parole. We understand that people who are incarcerated, you have to give them hope, you have to train them, and you have to reintegrate them into society. But what we look at when we're dealing with this sort of most violent portion of the offenders, that I have to ensure when I'm going out there in policing, and I worked in one of the 20 years in Regent Park, one of the most challenging policing in Toronto, where we dealt with people who are on parole. And I appreciate, you know, the concerns about having this monitored, or as you say, but there are a lot of costs associated to having people monitored once they are released on parole. And again, when we're talking about policing dollars, who's going to pick up that cost and who's going to do that? We had several houses, halfway houses in, well, the largest density in all of Toronto, and being able to monitor those people on 24 hours, and like when we're talking about people who have substance abuse issues, and those are the triggers, it creates a very difficult position for policing. So we have to be really sure that when we're releasing people into the community that they're being reintegrated, and there has to be that support structure. But again, the costs around that are going to be very challenging.
Yeah, and I totally agree with you. And there was a case in an individual released, I believe, from Saskatchewan, who was monitored, and they found his monitor on the top of a rooftop somewhere. He actually ended up in the United States. So in terms of monitoring, that doesn't necessarily say everything is good, because this individual wanted to get back to the U.S. because he happened to be a U.S. citizen. So I think that there needs to be some more process around that and to tighten up the rules. So anyway, I want to thank you all for coming today and important information you provided.
Fine. Thank you, Mr. McCormick. Thank you, Mr. Payne. And Mr. Easter, 5 minutes, please.
Thank you, and thank you, Mr. Chair. And I want to thank all three witnesses for coming and presenting, I think, very heartfelt views. Before I raise a question, Mr. Chair, when are we doing clause per clause in this bill?
The committee had adopted a motion while I was on government business to do this study at clause by clause on February the 27th.
Okay, that's. I would suggest, Mr. Chair, that to the witnesses first, Ms. O'Sullivan, I think, made a number of very sensible suggestions, and I think Ms. Lee's concern about recordings and video will be dealt with amendments coming forward from committee members based on her testimony. But excuse me, Mr. Chair, there's been a number of, I think, very good additional suggestions for amendments by the witnesses today. I think we need to see a transcript of that, of what the witnesses said, and I do think we need some time to prepare those amendments, and we can't have them done by Thursday. We just can't. So I'd suggest maybe the committee, yourself, or maybe the parliamentary secretary reconsider, if we could, that, because we want to do the best job we can on the bill, and there's some good suggestions here. In any event, one of the suggestions, and I guess to you, Ms. Lee, that has come up a lot of time by several witnesses, and I think by Mr. Sweet as well, is that victims have no way of being informed of how well an offender is doing on their rehabilitation plan. There's always the privacy issue comes up, but I'm sure that can be dealt with somehow. How important is that to victims, from anyone who wants to answer?
Well, as I mentioned before, I currently get information, or I was currently before he got out, on different programs that he had done or hadn't done, and I found what he hadn't done was very interesting. And it was, I would have liked to have more information along those lines. They were very, very cursory, just what was the program and whether he passed it or he didn't attend it. But nobody told my family and I what was the plan for him. How did they envision him getting out and being a functioning member of society? It was only about these actual programs that he attended. So I think if they could flesh that out and help us to understand their thinking about why. I mean, none of us as victims want them to be out of prison, but if that's going to happen, we want to make sure that everyone is as safe as they possibly can be when he does get out. Like the killer in my case was on a scale of 2 out of 3 on recidivism, that he wasn't going to reoffend, but yet they let him out anyways. So, and that was, you know, how it worked.
Mr. McCormick, do you want to come to that point, and can you add in several witnesses in terms of the time frame? And Mr. Sweet's bill goes up to 5 years. But as I listened to you, Ms. Lee, this morning, it seems to be that the hearings are even in quicker periods than is already stated in the current Act. If so, why is that so, and how are we going to ensure that that you can be assured when the next hearing is, rather than jeopardizing your life and changing schedules?
Well, I think twofold, that, you know, there has to be a demonstrated material change. It can't just be the current system now where, like, for instance, with Monroe, as soon as he gets denied parole on the first hearing, he's booked his next hearing date already, and saying, okay, well, where's the material change? Where does that come forward? And I think that that's going to be significant. And how do you demonstrate a material change when you don't have any information, when they're all shrouded in this privacy interest? And that was a great question you asked Ms. Lee here, because with Monroe, for instance, and what I said earlier, is one of his triggers for his homicidal behavior and antisocial behavior was drug or alcohol. And he had some prison issues, and that was not disclosed, and we had to find that out, and it wasn't disclosed, and there was no transparency there. So when you got a murderer, a violent murderer, sadist, who is triggered by drug use, and sure enough, they give him an escorted day pass, and then they revoke that, or the escorted day pass, then they give him unescorted, and his parole gets revoked, and we're trying even to get information why his parole was revoked. And it is such a closed shop when it comes to victims. Victims are kept way outside of it.
Thank you very much, Mr. McCormick, and thank you, Mr. Easter. And we've now finished our first hour plus, and the chair, on behalf of the committee, would certainly like to thank our witnesses for coming in here, taking their time and certainly their story with us and helping us deliberate, obviously, legislation that we hope will be most helpful to one and all. So we will suspend for 1 minute while we change for witnesses. This committee will now resume for our second hour, although we may not have the full time due to bells. We will have to see how it all goes here, but certainly the committee would like to welcome our guests here today. Steve Sullivan, thank you, sir. Catherine Latimer, and Terry Furiello, if I got that correct. The best on that. Well, thank you very much for coming here again as well before this committee to discuss Mr. Sweet's bill. And we will start off for up to 10 minutes, and if it's less, that's fine. It gives us more opportunity for interaction. Mr. Sullivan, we will have you up first, please.
Thank you, Mr. Chair. Thank you for the invitation. I'd like to congratulate Mr. Sweet for his efforts to address some of the concerns that victims of crime have expressed. I'll try to keep my comments brief so we can get to more questions. I'll just quickly touch on a few of the aspects of the bill that we support or have concerns about. The first is with respect to the extension of the parole hearings. I would encourage all members to, I'm sure you all know this, that parole is actually an integral part of public safety. And we often talk about parole as, well, people are getting out of prison early. Quite frankly, I think we want people to get out of prison early. If we wait till someone's sentence is over, we have no controls over them. It's better to have someone released early With a little bit of control, you have a parole officer you're reporting to, you can be brought back into prison if you're violating the rules, as opposed to waiting or detaining somebody or gating them, as Mr. McCormick said. So I think it's important to frame the context that parole is actually a really important part of public safety. When I was ombudsman, one of the recommendations that we made was to extend the parole hearing, or to have a system where you could extend the parole hearings for lifers from 2 to 5 years. I look at lifers as a bit different. Those aren't people who, by law, ever have to be released. You know, if they've met the conditions, they're a good risk, they can be released. But unlike someone who has a 6-year sentence, after 6 years, whether they're dangerous or not, or whether we think they're dangerous, they're getting out of prison. With lifers, we have the ability to keep those people in prison for longer. And as Ms. Lee mentioned, and I'm sure as Terry will, I've been to a lot of parole hearings with a lot of families. I've been to parole hearings with families several times for the same offender. It is a very difficult process. Many people feel they need to be a part of that process. So I think there could be some room for extending the parole hearings for lifers to 5 years without impacting public safety. I think doing it for offenders with finite sentences would actually could have a negative impact on public safety. I'll move on to the other parts of the bill. I certainly support the suggestions to legislate some of the practices and provisions that are in place now for victims of crime to attend parole hearings, for example. I've been involved in very few situations where victims have been denied that right, but I think it is an important right to legislate. If we believe that victims have a right to attend a parole hearing, then I think we do have an obligation to legislate that right. I found the wording of the provision a little awkward, but I'm not a legislative drafter. But I think I would make that provision a little bit clearer. Obviously, a right to attend a parole hearing is not unlimited. If someone presents a risk or there's reasons not to, then I think that's an important limitation to have on and would be in the provision. I remember one case where there was an individual we worked with whose mother had been murdered, and he had made some unfortunate comments, and the decision was not to allow him to attend the parole hearing. But he was allowed, through our efforts to help him, to attend via video conferencing, which was a good compromise. Which brings me to the next provision. I think it's been repeated by others. I would not limit the right to attend a parole hearing via video conference to people who were denied a parole hearing. I think that's an important right for people who can't travel. When I was the ombudsman, we worked with a family in the case of where the victim had a serious physical injury as a result of the offense, couldn't travel. It was very difficult to travel long distances. So we worked with the parole board, with corrections, to arrange for his family to be a part of that parole hearing through video conferencing. It was the first time it had ever been done for a victim. They had done it for board members, and I'm actually attending a parole hearing coming up in a few months where the parole board members can't attend to the prison, so it's going to be done via telephone conference. So I'll be with the family. We'll be in a different location than the parole board and the offender. So it can be done, and it is done when it's necessary for parole board members. I would extend that to victims as well. There may be situations where the equipment is not available, but I think when it is and when it's available, it should be provided. I would support the requirement that the parole board consider victim impact statements. That would be consistent with the criminal code provisions where judges are required to consider it. It doesn't mean they have to follow recommendations or provisions that victims bring up, but it is, I think, an important legislative right to actually consider those statements. I do support, and when I was ombudsman, we did recommend expanding. Currently, under the provisions right now of the CCRA, there's certain information victims must be given. It's very basic information. And then under section 142, there's provisions that victims can be given if it doesn't violate, or I forget the wording, violate the privacy of the offender. We recommended, or I recommended as ombudsman, that all those provisions be mandatory, with, again, the assumption that if there are cases where the parole board or corrections feels that it would be a risk to release that information, it can be withheld. Certainly, it would be very rare, but situations where victims have made threats or where there's a situation of organized crime or gang involvement, you would have discretion not to release. But I think the presumption should be that you would release those. I would release all those provisions in section 142. I know the bill specifies a few of them, and I think if you're going to amend section 142, You also then have to amend Section 26 because the CCRA sort of focused on two. There's the parole board side and the correction side. Both agencies release information to victims. I don't think it would make much sense to allow the parole board to release more information than the correctional service would. As far as the correctional plan, I don't really have, to be honest with you, I've never seen a correctional plan. I don't know what is in correctional plan, so I would have a hard time saying I support that. I'm sure there's information, maybe summaries that could be provided, but as far as what's in a plan, there may be a lot of information that victims, private information about members of family. Again, I don't know what a plan was, so I would encourage you before you debate the bill to find out really what's in a plan. Catherine may have more information than that. I can tell you I did bring, we're registered to receive information on behalf of some victims, so I've removed all the identifying factors. This is what victims would get now about an offender. It's just really a list of all the programs that he has taken or he has signed up for, whether he's completed or not. Just tells you what it is. For example, anger management awareness, says when and says whether it's completed or not. That's the kind of information that's available to victims now. Whether there's more information in a correctional plan that's of value, again, I just don't know enough about those plans. The transcripts, my understanding is the parole board doesn't actually prepare transcripts. I can tell you, having been to a number of parole hearings with the same offender, that every parole board hearing I've been at where it's been new members, they know exactly what happened at the last hearing. The notion that new members wouldn't know what was said or done at the previous hearing, that isn't my experience. The parole board members, especially in cases of lifers, have stacks of files of the offender's entire history in prison. So they have a pretty good understanding of what he has or has not done. They also have a pretty good understanding of what he has and has not said at previous hearings. So I think that's it's an important point to make. So I mean, I think requiring the parole board to prepare transcripts could be quite expensive. And frankly, I don't know that, I mean, we made recommendations at the Ombudsman's office, and actually in 2005, it was introduced by the previous government, that victims would have the right to listen to an audio tape of a hearing. I think that's a more practical and frankly useful provision to have, to allow victims to attend a parole office to hear those hearings. I think I'll leave my comments there, and if there's other issues, we can certainly address them during the question.
Well, fine. Thank you very, very much to Mr. Sullivan. And now, Catherine Latimer, please.
Thank you very much. I'm with the John Howard Society of Canada, which is a community-based charity whose mission is to support effective, just, and humane responses to the causes and consequences of crime. The Society has more than 60 frontline offices across the country, offering many programs to support the reintegration of offenders and to prevent crime, and the objective of our work is to make communities safer. I want to thank you very much for the kind invitation to speak to you about Bill C-479, which proposes amendments to the Corrections and Conditional Release Act affecting the role of victims at parole hearings and lengthening the time between parole hearings in certain cases. The stated intention of the bill is to bring fairness to the victims of violent offenders. I think we all share an interest in supporting victims with adequate programs and services and with information about the criminal justice system, and I'm sure that information about the paroling system can be greatly enhanced. More challenging is finding agreement on the appropriate role of the victim in the criminal justice system to ensure the fundamental principles of justice are maintained and fairness is upheld for all. The John Howard Society of Canada looks forward to the government's announced Bill of Rights, Victims' Bill of Rights, which will hopefully provide clarity on some of these important issues. Bill C-479 is being considered before the government has revealed its comprehensive strategy for victims in the criminal justice system. If passed in its current form, the likely consequences of this bill raise two categories of concern. A, its practical implications for the effectiveness of safe, graduated release generally and victim prevention, and B, its implications for the theoretical foundations of criminal law and corrections, particularly in the proposed role of the victim in the parole hearing. I will deal with the practical effectiveness issues first. The research is clear, and I agree with Steve on this, that supervised and supported graduated release of prisoners back in a community promotes community safety by reducing recidivism. If prisoners are unmotivated to participate in rehabilitation programs and be guided on parole at the end of their sentences, they may well return to our neighborhoods lacking the skills and guidance needed to live crime-free lives. Eroding supervised and supported graduated release of prisoners imperils community safety and increases the number of victims in our society. This bill is very sweeping in its effect. It proposes lengthening the time between parole hearings for those prisoners who have committed offenses listed on Schedule 1 of the Act, which includes 76 current offenses and 18 historical offenses, not all of which are violent or caused serious physical harm to offenders. Right now, there are 11,286 federal offenders that are covered by Schedule 1. So this isn't a few murderers or dangerous murderers. This is a whole swack of offenders, federal offenders, who are covered by these provisions. If these prisoners are denied parole at a hearing, they would only be entitled to another hearing within 5 years. But since most federal prisoners are serving sentences of less than 5 years, this would mean just one chance at parole for them. The majority of prisoners would thus not be released through the parole's graduated, supervised, and supported release process, but instead would be abruptly dumped back into the community at statutory release or at warrant expiry. While it may be comforting to believe that the longer you keep prisoners in custody, the safer communities are, this is simply not true. Those released at the end of their sentences have not prepared themselves with skills and are not being supported and supervised through community corrections. Bill C-479 would put in place a system where more prisoners would be denied the benefits of graduated release and would reduce the chances of those returning to the communities remaining crime-free. This would compound an already growing problem in the corrections system. Just to let you know, more than half of offenders now see their first release at statutory release or warrant expiry, not through the benefits of the paroling system, and this will exacerbate this problem. The second set of concerns posed by Bill C-47 deals with the appropriate role of the victim at the parole hearings, consistent with fundamental principles of justice. Essentially, a parole hearing is to assess whether a prisoner has made progress on his or her correctional plan, what level of risk might be posed if the sentence were managed in the community, and whether conditions could be imposed that would make the risk manageable in the community. It is not to revisit the punishment which has been imposed by the court through the sentencing process, where victims have already had an opportunity to provide a victim impact statement. Input from a victim at a parole hearing would need to be relevant to the decision before the quasi-judicial body. But since the parole hearing is to assess progress on the prisoner's correctional plan and to assess risk management issues in the community, a statement by the victim who may not have knowledge of the prisoner's progress on the correctional plan and limited expertise on community risk management, it hardly seems appropriate at this stage. There is, of course, a legitimate role for victim statements relating to possible conditions on release, but this should be clearly detailed and set out in the bill. If the victim has received threats directly or indirectly from the prisoner, or if the prisoner will be returning to the same family or the same community as the victim, conditions like no contact orders could be included as conditions of parole, and this seems entirely legitimate. More challenging is the notion that the prisoner's entitlement to regular reviews, once he or she is eligible for parole, should be reduced in order to provide fairness for victims. This interest of victims not to have to attend regular parole hearings compromises the prisoner's right to have a level of reduced liberty in the management of his or her sentence reviewed consistently with fundamental principles of justice. The legitimacy of trading liberty rights and protections based on fundamental principles of justice with victims' interests will no doubt be discussed more fully when the government releases its Victims' Bill of Rights. The general reconstruction of crime, bail, punishment, and parole as a battle of criminals' rights against victims' rights is part of a wider transformation of rights thinking in Canada, which some of us consider to be an unfortunate direction. Where before rights were understood as protections of the individual dignity of all humans, even criminals, against the state, now they are increasingly presented as weapons employed by one group against the other, with the state choosing the victor. We must ensure that even in this new rights ideology, convicted criminals are still treated with the humane respect required by the long traditions of the common law. In conclusion, the John Howard Society of Canada urges you to postpone your consideration of Private Members Bill C-479 until after the government has introduced its own bill, which is expected to deal more comprehensively with the rights of victims in the criminal justice system. The potential for overlap and inconsistency of proceeding first with this bill is strong. The John Howard Society of Canada also urges you to consider more fundamental review of the current effectiveness of the current paroling system in Canada. Promoting rehabilitation and successful reintegration through an effective system of graduated release is a good way to reduce future victimization. Implementing this bill, with its attendant denial of many prisoners to a second parole review before statutory release or warrant expiry, will effectively gut the existing parole system. The system of one-shot parole for the majority of federal offenders will be ineffective in meeting the statutory goals of graduated release. While we support programs, services, information, and defined participation of victims in the criminal justice and correction system, Bill C-479 will undermine a graduated release system intended to promote community safety and reduce victimization generally. This bill is certainly not fair to future victims. Thank you very much.
Thank you very much, Mrs. Latimer. Appreciate that. Now we will hear from Mrs. Prairie Yellow Armour.
Good afternoon, everyone, and it's an honor for me to be here today to speak to the Corrections and Conditional Release Act, Bill C-479, Fairness of Victims. I would like to first thank Mr. Sweet for inviting me here today to speak to you about Bill C-479 and for bringing this important legislation for fairness. I am the sister of murdered victim Darlene Pirello. Since Darlene's murder, our family has had many occasions to feel re-victimized. Some of these would include hearing the man who killed my sister brag about his bedroom with a doorknob that can be locked from the inside. Another example would be watching a video of Mr. Dobson being interviewed by the parole board saying time is easy to do. Time is easy to do. It made us feel that our justice system is not punishing these victims, these offenders, but simply housing them. It is like sending a child to their room and letting them know at the same time that they are still loved. It is like when David Dobson had his first parole hearing in April of 2007, I remember doing my impact statement and feeling so re-victimized. At times I could only write a paragraph and then I'd have to stop. At times I would stop for hours, and sometimes it would take me weeks to be able to sit back down and do my impact statement. When I finished my impact statement, I called my mother to ask if she had completed hers. Sorry. She said she couldn't get it started. She asked me to read her mine. And as her daughter, I felt I had to do something to help her. So I read mine to her, and she cried and she sobbed all through my reading of it. And then I sent her my impact statement afterwards, and I said, Mom, personalize it and make it your own, as I felt like I needed to help her. I needed to do something for her. I thought, I lost a sister, and being a mother myself, there's no comparison losing a sister to losing your daughter or your son. There's no comparing. I had to start my impact statement all over again. Some weeks later, my mother called and said she had finished her impact statement. She sent it back to me and asked me to read it over and give my opinion. Well, much of my original impact statement was there, but she turned my 2-page statement into many pages. I couldn't believe that she had survived this, the stress, the heartache. My mother was hospitalized several times during the making, just during the making of her impact statement, due to the having to relive the crime all over and her her daughter's death. The entire family felt very helpless. We couldn't tell her that her health was more important than a statement or a parole hearing, as she didn't see it that way. She saw this as something she had to do for her baby, for Darlene. We had to then send our statements to the parole board for them to review. And then they'd send it to David Dobson, my sister's killer, for his approval. We were then asked to make changes to our statement, as Dobson didn't like some of the things in our statements. We also got reminded that we must show respect for the killer at all times. The impact statement should be about our feelings, should be about what was taken from us, not about worrying about his feelings and his emotions. This is our impact statement, not his. When we talk about respect, respect is something that is earned. It's not something that should be demanded. It's not given, it's earned. My question is, where was my sister's respect when he brutally sexually assaulted her and beat her head into the ground with a concrete building block? We found it also very victimizing that David Dobson got to read our statements, but we had to go into this parole hearing with no idea of what he was going to say, as we didn't get to see his statement. We didn't get any heads up. We had no way to prepare ourselves emotionally for what we may hear in that room, in that hearing. My question would be, why after a brutal attack on a loved one that resulted in their death, does it appear that the perpetrator of the crime is treated so well in our system? Remember, time is easy to do, he said. Before the hearing, we had been told that David Dobson knows he's not getting parole, but he said that he wanted to see how the system works. He had no place to stay if released, no job, no way to shelter or feed himself or care for himself. We went through hell and back for his entertainment because he felt he had to do it, because he felt that he needed to see how the system works. Question, why does legislation allow this? And shouldn't this be re-examined? At the hearing, my mother, my husband, my daughter, my uncle, and I sat together. David Dobson came into the room. He looked straight into the eyes of my mother, and then into my eyes. I can't tell you how that felt. I felt his look take my breath away. I'm sorry. I was looking into the eyes that last saw my sister alive. I was looking at the last face that my sister ever saw as she begged and cried and pleaded for her life. I'm sorry. His eyes were so cold and empty of feeling. He sat in his chair and shortly after started to cry and cried continuously through the whole hearing. We felt that this was for the purpose of drowning us out as we read our impact statements. At one point, David Dobson looked at my mother and said he was sorry, and my mother replied, "I don't believe you, and I don't buy your tears for 1 minute." One of the parole board members reminded her that she was not to speak to the inmate. But there was no direction given to David Dobson about speaking to my mother at this hearing. I would like to think that the parole board would see how hard this is on one's family and demand that the killer show the same level of respect as we are demanded to show to him. Again, where was the respect for my sister when he was killing her? Before she died, he didn't show her any respect. The last act he committed to her was to pee on her. He called it the best urine he'd ever had. Dobson made it a point to tell us during this hearing that he had hung a cross in a chapel in Darlene's memory. When we called the facility, they said that this was just absolutely not true. We believe that this was his way of getting a thrill of reliving his crime. This is typical of a killer to want to revisit the murder in any way possible. The hearing gave him that opportunity. We gave him that opportunity. This may be the inmate's hearing, but this is our loss. While we sat in the room, my mother felt ill and she was taken out and shortly brought back. This was just too overwhelming for her. Sometime before the hearing, I had met with two of David Dobson's sisters. One of them told me that during a visit with David Dobson, that he told her upon his release that he wanted to visit with Terry Pirello, and it wouldn't be nice. If you check our website, www.nofreedomdobson.com, you'll see his letter of Catch Me If You Can, where he promises to kill again every year possible on the anniversary of my sister's death. Keep in mind, he didn't know her, had never seen her until the day he killed her, but it's their anniversary. So you put those two things together, his promise to kill again and his threat to me through his sister. It's no wonder when I sat in that room, no matter how many guards were in there, I couldn't help but to feel I still wasn't safe. And yet in our statements, I wasn't allowed to tell the parole board about this because it wasn't my hearing. And what I had to say was not allowed to be used to help influence the board's decision in his parole or lack thereof. I believe that a serious offender should earn the right to a hearing. Our family asks that the Corrections and Conditional Release Act include an amendment that gives the parolees an earned right to a hearing every 5 years versus current 2 years without grandfathering. Make the amendment retroactive for all offenders. I see the same system that is meant to protect us as a flawed system. I know that serious offenders are given the option of courses to help them to reintegrate back into society. I believe that these courses should be mandatory, not optional. I also believe that that list of courses to reintegrate into society should also be lengthened, more courses.
Sorry, we have to close off to have a little bit of time for questions. Thank you. Point of order?
I hesitate to do this, but it must have been incredibly difficult for her to do this today, and I would ask for unanimous consent of the committee to allow her to finish her statement if she could make it
Not
brief.
much longer.
If that consent is available, the chair is certainly comfortable with that. The committee is certainly comfortable. I thank you for the intervention. Please carry on.
I thank you very much. Economics or lack of space should not be the overdriving force to an inmate's release. It appears at times that some of our inmates are treated better than some of our seniors. In closing, I would like to ask that Section Bill C-479, Fairness for Victims, be named after two people. My sister, Darlene Prirello. Her murder was so brutal. I have been a long-time lobbyist, fighting for victims of rights, as Steve Sullivan can attest. It would be an honor to have Darlene's name stand for more than just being a victim. To know her name stands for fairness is so fitting to who she was in real life. As her headstone on her grave reads, she gave so much and she demanded so little. The second name is Constable Michael Sweet, a 6-year veteran of the Metro Toronto Police Department who was murdered by career criminals Greg and Jamie Monroe. Constable Sweet was shot by Greg Monroe and held hostage by the robbers. Constable Sweet fled for his life, but the robbers refused to even give him medical treatment. It would be an honor to have this bill named after two strong and remarkable people. I thank you for listening and for your consideration to the fairness for victims and the naming of this bill. For those who love, time is eternal. Thank you.
Well, the chair and the committee certainly thank our witnesses for your heartfelt testimony, and I know just from listening and talking and watching the faces and the witnesses here today, obviously on all sides of the occasion there's some deep concerns and challenges that we all face, both as legislators and certainly you as family. We have a very, very brief time right now. We will, depending on when the bells will go, but Mr. Easter, you have the first round of witness. You have 5 minutes, please.
Okay. Well, I'll just keep it to 3 and try and
thank you.
Cut me off at 3 there, Chair.
Point of order, yes.
The second hour of witnesses, the first round goes back to Conservative over here, then NDP, Conservative, Liberal.
Pardon?
No problem. Go ahead.
My apologies.
Not a problem.
Thank you very kindly. I was just looking at down through here. Yes, Mr. Norlock, please. My apologies, sir.
No need. Thank you, Mr. Chair. Through you to the witnesses, thank you for being here, and to the victim of Mr. Dobson. I have to say that we must, as legislators, look at this dispassionately. But it sometimes is difficult to do so when you hear certain stories. And I want to just start my questioning by realizing that this is somewhat of a parole hearing, like a parole hearing, that you're being asked to revisit it again. But I can assure you, and I think I speak for all parties, it is not in vain, and we appreciate you doing so, as well as the other witnesses that are here. I did take advantage of the No Freedom for Dobson website to look at it. And of course, I recently read your family's experiences with hearings, and where it stated that you ripped up your victim impact statement in frustration during the review because you weren't able to say what you wanted. And I quote from it, and this is a quote. They said, "Well, you can't say the word monster. You can't call him a product of the devil. It's disrespectful." And then you further said, "Well, where's my sister's respect when he was murdered?" So I just wanted, when he was murdering her. I think you're completely right to say that. There's been an imbalance in our system. And I think what we're trying to do is bring back balance. And it seems that part of the goal of this bill is tilted, that the balance is somewhat backwards when we're dealing with rights of victims. And I wonder if you could comment on how you felt your rights were violated through the process and how parts of this bill might be and could help you during those hearings.
I think if the system was balanced where, as I've said, that the hearing's got to start being looked at as being our hearing as well, not just the offender's hearing, because we could have helped I mean, thankfully he didn't get parole, but if they honestly were considering parole at that point in time, I had something I felt very strongly could have helped them to make that decision to not release him, because when you can send a threat through your sister to, I mean, he literally gave the message to his sister to deliver to me that when he got out of jail, he wanted to visit me, and it wouldn't be nice. And then in his letter, Catch Me If You Can, we call it, as you may have seen on the website, he promises to kill again every year possible. Do you really think that in a parole hearing that I shouldn't have the right, as the family of the victim, to let you know this? I think this is pertinent information. I think the parole board should have to hear that, because if he's in jail for 20 some odd years at this point, I think 22 years at that point, and he can still send a threat of my well-being home for me, is he really ready for parole? With his own wording, promising to kill again every year, to back that. The parole board wouldn't hear it. This is something that's got to, the balance has to be put there where this is our hearing too.
Thank you for that. I have one other question. I think the time clock is running very quickly, but why do you believe it's important for the public, and especially the victims, to know about the offender's correctional plan and evaluation on the road to his or her rehabilitation?
I think it's important for us as the family to know what courses he's done, which we do get that. But it's important to know that there's some that are mandatory, because to say, well, here's a list of things that, you know, will help you to reintegrate back into society, we hope you'll take advantage of them, it's not good enough. You have to remember, when they're in jail, they lose the right to use money, to wait for a bus, to just do common courtesies and common pleasantries. They need to know this stuff, and I'm all for a criminal who's served their time coming back out onto the street, but make sure they come back out ready to tackle the world, to know what they're in for, so they don't come out, freak out, get scared, and recommit the only crime they know to get back in again. So if they've committed murder, as Dobson has said on our website, in his own parole hearing, jail is the only home he's ever known. If you want to go back home, you get in your car and go and see the old neighborhood. For him to go back home, as he knows it to be jail, he's got to kill again to do that. It's important that we know that they've taken these courses, that they're mandatory courses, that they are completely and totally ready to face society again, safely and securely.
Now, Mr. Garrison, just a few minutes.
Thank you very much. Given that the bills may go at any minute, I'll be a bit rushed here, but I do want to thank all the witnesses today. We've certainly heard much to consider on the frequency of hearings for those convicted of murder, and I assure you we'll take that very seriously. I do share Mr. Easter's concern you raised after what we've heard today, that we're proceeding to clause by clause on the 27th, because we've heard some very good suggestions for amendments, and that's things.
Practice has been, when the bells go, that obviously we adjourn. It would take unanimous consent to carry on for a couple of minutes.
Could I ask for unanimous consent? It's 30-minute bells, and we are in the same
I realize, but the committee's practice has been to do that, and I have not set a standard different, and so the chair will enforce that. However, if the committee wants to have unanimous consent to allow you to finish your questioning, that would be up to the committee. Do we have unanimous consent? Yes. Yes, we do, sir.
Thank you very much. So I do share the concerns, and I hope that we'll have committee business on the agenda for Thursday so we can revisit the question of how quickly we proceed, and especially with the concern I raised earlier about the parole board apparently declining to appear on legislation which will affect their operations to a very large degree, and we'll have a look at that correspondence and see if that is in fact true. I want to focus my questioning on a couple of things that were raised by Mr. Sullivan and Ms. Latimer. We heard from the previous representative of the Quebec Victims Group, and she made a distinction in this bill between those convicted of murder and those Schedule I offences, and I think both of you also made reference to that. And when Ms. O'Sullivan was here as the Victims Ombudsman, she said that that is not what her original recommendation was. Hers was limited to murder only and not the Schedule I offenses. So if I could hear just a bit more from both Ms. Latimer and Mr. Sullivan on that distinction between those convicted of murder and the Schedule I offenses. Yeah, thank you for the question. Yeah, actually, I was the ombudsman when we made that initial recommendation, and it was limited to those doing life sentences. It wasn't for anyone doing a violent offense. I think the proposals in the bill could have a negative impact on public safety for some of the reasons that Catherine pointed out, that some guys may only get one chance at parole. Although it may not be publicly popular, we do want to see people get on parole because it does enhance public safety. Thank you. Ms. Latimer.
I agree with that. And in fact, I think you could even parse the categories of murderers. A lot of murderers, and not the psychosexual serial killer type murderers, but a lot of one-off murderers are actually your lowest risk people when they are actually released on parole. So I think you need to look at, distinguish serial killers, sadomosexual, and others, and maybe have a very narrow category for some that are the highest risk, the dangerous offender types.
Thank you. Ms. Latimer, you raised the interesting question of if we created what you called a one-shot system, that it would reduce incentive for offenders to participate in rehabilitation activities. Can you say more about that for us today?
Given the length that most federal offenders are actually serving, there would be extreme unlikelihood that they would get out on parole. Most people do not get parole on their first appearance. If they're going to have to wait another 5 years, then what is the point of participating in the programs to fulfill your correctional plan if you're going to wait till stat release or warrant expiry in any event? So I think you lose the part of the incentive, which is the motivation that encourages people to prepare themselves for release if a progressive release system is not going to be in place.
And I probably just have time for one. Okay. We heard from a couple people that the legislation should be amended to insert a requirement that the parole board consider victim impact statements. And I'm going to stick to Mr. Sullivan's Latimer again. Would you be supportive of that provision that the board be required to consider those statements?
I have no problem with that, but I would prefer that the comments be relevant to the decision that the quasi-judicial board is considering at that time. And there is, as you've heard from many of the victims who have appeared before you, it's very difficult not to go back to the original offense and want to hold inmates continuing to be accountable for that initial deed. But information like whether they've issued threats, whether that is all relevant, and I think should be part of an accepted statement.
Yes, Mr. Richards, 2 minutes only, and that is it.
Okay. Thank you, Mr. Chair. And I want to thank all of our witnesses for being here today, but particularly Ms. Priorello Armour. Thank you so much for being here today. I can only imagine for both yourself and Ms. Lee. As I said to Ms. Lee after her testimony, I just wanted to come and give you a hug when I listened to you, because I'm sure that you've needed many hugs and many helping hands over the years. I can only imagine what it must have been like to have to share your story a number of times and to be re-victimized in that way. And I think that's really the question I'd like to just kind of ask you for a little bit more. And you have talked about it a bit already. And you mentioned specifically about the sort of the "Catch Me If You Can" letter that you have posted on your site. And obviously this is what the intention of this bill is to do, is to deal with the re-victimization process that victims have to face when they have to continually go to these further and further parole hearings. And Ms. Lee put it very well. She talked about it, how every 6 months it almost seemed to be the case. And I wonder if you could just give us a bit of comment on how much difference you think it would have made to you had this bill been in place in terms of ensuring that maximum that window of 5 years. Would that have made a pretty significant difference for you?
It would have made a huge difference, because we've only had one parole hearing, but we've prepared for 3 of them, because 2 other times he has said, yeah, I want my parole hearing. So we went through the process of doing the impact statements, got everything put in, sent it all in, And then he said, yeah, nah, I canceled. I don't want to do this anymore. So 3 times within 6 years, we relived what we didn't have to. And
Thank you for your answer, and thank you for
Fine.
thank you.
And thank you very much, and to all of our witnesses, on behalf of this entire committee, again, of safety and national security, dealing with legislation that is important to public safety. Thank you very, very kindly for attending, and I thank my colleagues for the courtesies here today. Meeting adjourned.